case briefs, and so much more. LSData's got what you're looking for.
In a curious 1983 case brought forth by the Hamilton County Municipal Court, the question of voluntarily abandoning criminal intent was put on trial. The case was named State v. Arnold. Caught in the act of stealthily attempting to steal 4 packs of bacon worth $2.85 each from a 7-Eleven convenience store by hiding them inside his coat, Michael W. Arnold became the focal figure of the case. After the store manager spotted Arnold, he quickly returned the pilfered bacon and rapidly left the premises. In court, Arnold pled not guilty to attempted theft, arguing his change of heart had led him to abandon his initial criminal intent, thus pleading innocence before he was apprehended. The crux of this case revolved around the interpretation of the voluntary renunciation rule under RC 2923.02(d), which could potentially provide a legal avenue for Arnold's defense if his abandonment of theft was indeed voluntary. However, the court, after much deliberation, held that Arnold's supposed abandonment was not self-initiated, but was rather a result of being spotted by the store manager. As such, the court noted, the abandonment could not be considered voluntary pursuant to RC 2923.02(d). In line with this interpretation, Arnold's defense crumbled. The court concluded that since the abandonment of criminal intent wasn't voluntary, he indeed was guilty of attempted theft, as he originally intended to commit the crime. Thus, the court upheld the original charge against Arnold. The case illuminated the significant influence of legally defined voluntary abandonment on defenses in theft crimes.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.